of the Queen Mary School of Law Immigration LLM program. We have an annual lecture, of course, every year, and you can see our past lectures if you look them up on the website, and you'll see that there has been a tremendous number of extremely well-known people who have participated in our annual lecture. My name is Elspeth Gild. I am a Jean Monnet Professor ad personam in immigration law at Queen Mary, and I am also emeritus at the Radboud University in the Netherlands. It's my pleasure this evening to chair one of the unsung, or perhaps unsung is not quite the right word, one of the heroes of trying to bring accountability to the borders, the external borders of the European Union, to prevent violence against migrants seeking to cross. My speaker is Lora Vidovic. She is the former Ombudsman of Croatia, appointed by the Croatian Parliament in 2013. And Lora was in place as Ombudsman when the substantial numbers of refugees began coming across from Syria through Turkey into Europe. And on account of the various border policies of the EU and the member states, they ended up, many of them, walking across the Balkans. Many of them passed through Croatia on their way to destinations where they had friends or family elsewhere in Europe, further north, where substantial communities of Syrians and Afghans and Iraqis are. And in 2015, you will recall, there were about 1 million people who came. And then again in 2016, about another 1 million people came. Of course, people don't leave just because they think it's a nice idea to walk across the Balkans in the winter. They leave because they are forced to leave. And the reception which they receive when they arrive at some place where they're traveling to, through, or will be their destination, depends to a very large extent on the state authorities there. Lora Vidovic, as the Ombudsman of Croatia, had a responsibility in respect of borders and in respect of what her mandate included borders. She found herself at the heart of this extremely contested movement of people across Europe. And in her role as Parliamentary Ombudsman, which is also a national human rights institution, an equality body, and a national preventive mechanism under the additional protocol of the Convention Against Torture. She took on board and was a leading voice and a figure to be followed in respect of trying to ensure that when these refugees arrived at the border of Croatia, they would not be subject to violence, but there would be a proper reception available for them and assistance to them. She has worked her whole career seeking to enhance the credibility of the institution of Ombudsman and of National Human Rights Institution, and also to secure its independence in promoting and protecting human rights and equality. These are themes that will undoubtedly come up in today's lecture, not least the contestation and the concern about the independence of ombudspersons and national human rights organizations in respect of their jobs in diminishing and stamping out border violence. She has worked on economic and social rights, rights of national minorities, migration, environmental rights, post-conflict issues, and the enabling of civic space. She is acknowledged in her overall work as an ombudswoman in the protection of human rights and democratic values, just last month, in fact, when she was awarded one of the highest French orders, the Chevalier de la Légion d'honneur, which is a very prestigious award, rarely given, and a great credit to Lora. Lora has had a long career in public office, both working for the Parliament and in the Ministry of Foreign Affairs before she took her job as Ombudsman. Now, just before I hand over to Lora, I will ask you all to keep yourselves muted. I will mute myself as soon as Lora starts. If you have questions, please put them either in the chat or in the reactions box. You can raise your hand. So you can either have one or the other, and we will take them up. We expect that the presentation, and there will be a short video after the formal presentation, will take about half an hour to 40 minutes. And so we'll have a good half hour for you to ask Lora all the questions that you always wanted to know about what does it mean to be an ombudsman. Lora, I'll hand over to you.
Well, thank you so much. Thank you so much, Professor Gild, for your very kind words. I'm certainly not a hero. I was just privileged enough to be able to have this job that actually allowed me access to the places in which I was able to contribute and hopefully support and improve the situation in 2015, but also later on. I'm also truly honored to have been invited to hold this year's annual lecture at Queen Mary University, and also thank you so much, Professor Gild, for the invitation. As you rightfully said in your introduction, and I would really like to emphasize that I'm not an academic. I speak from the professional experience and from my own work, and hopefully I'll be able to present some of that work to you when it comes to the rights of migrants at the European border. And hopefully I will be able to showcase that independent national human rights actors, such as NHRI's, national human rights institutions, are well positioned and should have much stronger role when it comes to the protection of migrants at the borders. Because, as you know, needless to say, they are basically deprived of any human rights and access to justice. Do you see my presentation? Did I successfully share the screen?
Yes, we can see it. It's fine.
Okay, so due to time constraints, and because I know you are also well informed and knowledgeable, I will not even try to describe the situation when it comes to migration currently as it unfolds before our eyes. I will instead try to focus on the work of NHRIs and other independent human rights bodies and the specific role that they have in the protection of human rights at the borders. And of course, I will give some examples from my own work as a former ombudswoman. The photographs that you see now are those taken at Croatian border in 2015 by either me personally or colleagues from the office. So this is the time period between 2015, as you said, when the mass migration of people started, mostly from Syria, Afghanistan, Iraq, but also African countries on their journeys towards Europe. And of course, also nowadays, as we see this very tragic situation at the Russian border. So as I bring really a practical perspective and from a point of view of very specific public institution, I will start my presentation by telling you more about some of those institutions because they still lack recognition and because they are often mixed up with one another. And at the same time, they do have a strong potential for better protection of migrants' rights that is not fully tapped into at a European level, but also at the national levels. And then at the second part of my presentation, I will speak more about what NHRIs have been doing the last 6 years and how can that work be improved. So in the EU, but also globally, there is a diversity of independent human rights actors at the national level. What all of them have in common is that they are established by legislation, meaning that they are state bodies. They are funded by the state. They are or they should be independent. There are guarantees in place for their independence from the government. At the same time, of course, because of that, because they are established by the state, they are not NGOs, they don't belong to civil society. They also have very strong role in the international cooperation, and there are international standards that guide their work. So they're not international, but national bodies at the same time. And therefore, some academics claim that they occupied the fourth space between governments, NGOs, and international organizations. So roughly, those bodies are NHRIs, ombudsman institutions, and national preventive mechanisms. And those three are the most relevant when it comes to the topic of this lecture. Other institutions, some of which are also independent, are smaller. For example, Ombudsman for children or for people with disabilities, so they have more limited mandate. There are also equality bodies established upon binding equality directives, and some of them work extensively on migrants' rights, but primarily tackling discrimination and working on equality issues, not so much on the rights of the migrants at the borders. So I will not go into the work of the equality bodies, although it's obviously very overlapping. Similarly, the data protection agencies are another type of independent human rights body envisaged by the EU law, but they are not relevant for tonight's discussion, so we will not go into more details when it comes to so national human rights institutions are established at the national level by preferably constitution, but some are also established by legislation. As I said, they are funded by the state, but also they are independent from the government, which is very important. And also they must have a broad mandate to promote and protect the full range of human rights. So civil, political, economic, social, and cultural of all people in the territory. Being independent means that they are accountable to the parliament as well as to the public. And they may or may not work on the individual cases, depending on whether they combine other mandates. But important thing is that they do not issue binding decisions, but give recommendations, opinion, policy advice, and similar. So the work of NHRI is as strong as their authorities, as their credibility is, as strong is the influence actually that they give. Now, the most important and distinctive feature of the NHRI to any other human rights structure or body or institution is that the NHRIs are regularly accredited by the Subcommittee of Accreditation of the Global Alliance of the National Human Rights Institutions, which is the global network of NHRIs, to assess whether they operate in the compliance with the United Nations Paris Principles. And the Paris Principles set out the minimum international standards for the roles and responsibilities of NHRIs. This very robust and rigorous process is supported by the OHCHR office in Geneva, and it operates under the UN umbrella. And so far, it is the only accreditation system that aims to assure institutions' independence, effectiveness, broad mandate, and other criteria that are established for their proper functioning. Then, those institutions that are accredited through that process to be fully compliant with the Paris Principle receive the status A. They are called status A NHRIs, and they are really recognized in the international and regional community as independent and credible partners. They have participation rights at the Human Rights Council. They speak immediately after the government. They participate in the PR process. they are invited by the treaty bodies to participate also. So this system, except in addition to the UN, is also recognized by regional mechanisms. EU heavily relies on the status of accreditation, so does OSCE, Council of Europe, and others. And then the institutions that are not fully compliant with the Paris principles, that are only partly compliant, are status B institutions, and they don't receive the same recognition, they don't have the same participation rights, because it is not confirmed that they fulfill all those criteria, that they are not independent, that they are not pluralistic sufficiently, and there are many other criteria, and I will not go into all of the details. It is not so rare that the institution that is status A can be downgraded at the subsequent accreditation, because the process takes place every 5 years. And just to give you an example of that, very recently at its last session in June 2021, SCA recommended that the Hungarian Commissioner for Fundamental Rights is downgraded from status A to status B. So it's actually assessed that it's not as independent as it should be, and noting with concern several issues, and among other, its work in relation to vulnerable ethnic minorities, migrants, and asylum seekers. So this is just to somehow show that this process really is important, it has relevance, and it is effective in presenting how independent and effective an NHRI is. Importantly, in Europe, NHRIs are connected by European Network of National Human Rights Institutions, ENRI, and you can see the logo on the bottom of the screen. So ENRI gathers more than 40 NHRIs across wider Europe, and it has devoted significant part of its work to migration issues. It has a working group on asylum and migration, and I will speak about that more extensively later on. But now I will quickly go through the other types of the human rights actors that work on the protection of migrants at the national level. So ombudsman institutions are some of those. And I'm sure, I mean, everyone knows the institution and the name ombudsman, because traditionally those were the first institutions to be established to protect citizens vis-a-vis public authorities. So ombudsmen investigate individual cases, most often upon complaints, sometimes on their own initiative. And traditionally, their work is rather narrow, looking only in legality of decision of public bodies. And those bodies have obligation to respond to ombudsman requests. And it is only recently that actually many ombudsman institutions have started applying human rights-based approach in their work. That is, recognizing that they work on human and fundamental rights and not only on maladministration. However, it must be said that it is precisely their strong legal work in the individual cases that is their stronger feature. And that is accompanied often with very strong public recognition and the authority, the respect the ombudsman enjoys by the general public, but also by the authorities. Unlike the Paris principles that guide the work of NHRIs, in 2019, the Ombudsman institution have also had their international standards. They're called the Venice principles. They're very similar to Paris principles. They reference it. But important thing is that in the Venice principles, there is no accreditation process, and there is no system of assessment of the independence and of the effectiveness, if the Ombudsman institution is a standalone and is not at the same time the NHRI. Finally, looking into those types of institutions that can work on rights of migrants at the borders, there are national preventive mechanisms. And as Professor Gald already said, they are envisaged by the OPCAT, which requires that each state party has one such mechanism established or designed to prevent torture and mistreatment of all persons deprived of their liberty in places of detention. Now, the interpretation of the NPMs or the NHRIs that are also NPMs is that the places of detention certainly covers also the green border and all the places where migrants may be detained or intercepted by the police. So this mandate definitely covers the area of migration. The basic idea behind the creation of NPM is that torture and other forms of ill treatment should be prevented, and that can best be done by independent visits of the places of detention. OPCAT also sets out requirements for the functioning of the NPM, and not surprisingly, independence comes at the very top, but there are also other requirements that you can see on the screen. The powers are to review the treatment of the persons deprived of the liberty, to make recommendations, submit proposals, influence policy change and draft legislation. And also, very importantly, NPMs must have unlimited access to all information, to all places of detention, and without prior notice. So the representatives of NPM go to places of detention unannounced and can speak to whomever they want to and can access any information they want to, at least in theory. Not to go into too many details now, let me just say that most member states have designated NPM mandate to already existing NHRI or Ombudsman, as those have likely had prior role in visiting closed institutions. And that brings me to the next slide, which gives an overview of the situation in European states. There are no international or European binding or soft law norms or guidelines that would predetermine or suggest preferred setup at a national level. So each state, due to its historical, traditional, cultural, political, whichever reasons, freely chooses which institutional architecture it wants to adopt and how the setup looks like at the national level. And in fact, there are no two models that are totally the same, even though there are some similarities. And if there's time and interest, I'd be happy to answer any question you might have in that regard later in the discussion. This is also an evolving situation as new institutions are being established almost every year in different countries. And every now and then there are initiatives to merge few smaller institutions into a more centralized one, which is also a topic of another discussion. So as you can see, the most often we have the situation that Ombudsman is the NHRI, so it's accredited, whether fully compliant or partly compliant status say will be NHRI and NPM, and that is the situation in most of the European countries. There are situations when there are two separate institutions, when the Ombudsman would be NPM, and then the NHRI is the self-standing and a different institution. And then there are countries in which there is one institution for each mandate. And then, of course, there are some specific cases. Some countries don't have NPMs, some don't have NHRIs, some don't have ombudsman institutions, which is pretty weird, but it is a reality in some countries. So, coming closer to the NHRIs, why are they well placed or even best placed to monitor and protect human rights of migrants at the border? Because they are state bodies with a strong legal base, because they are funded by the state budget, although always very restrictive and limited, and because they are connected to the parliament. This gives them very specific weight and certain authority. Then, although NHRIs are recognized as human rights defenders, they are not NGOs whose work is often questioned, particularly when it comes to the rights of migrants. So there is a specific weight given to the NHRIs that the NGOs don't have. Then those NHRIs that are status A, so that they are accredited as independent from the government, they are confirmed to be independent from the government and from the police authorities and from the border guards and from any political influence. And in addition to all of that, they also have a broad mandate. They have a duty and a legal obligation to protect migrants' rights. Not all of them obviously fulfill that obligation, but that's also another question that we may comment in the discussion. But yes, they do have what it, at least in theory, on the paper, they do have what it takes to efficiently protect migrants' rights at the borders. Also, as a rule, they have a power of unrestricted access to all places, all information, and can speak to any person regardless of their status, to the migrants, to officials, to health professionals, and they don't need prior notice. Public authorities have the obligation to respond to NHRI's requests, and those three powers, to receive response from the government, to speak to any person, and to have right to unrestricted and unannounced access, really puts them in ideal position to independently monitor rights of migrants. And this goes regardless of the institutional setup, as all three types of the institutions, NHRIs, Ombuds, and NPMs, whether separately or combined, fulfill those requirements. Now, when the mandates are combined, that gives comprehensive overlook, and it's always, in my opinion, better like that. But yes, the other options are also the case in many countries. Now, because NHRIs have a strong mandate on human rights promotion, I think that's also a very important point. They can significantly contribute to raising awareness about the situation at the border and of the migrants' rights, both at national and at European level, and that really significantly helps in the work. I can also say that from my own experience. Having all those mandates and powers, most European NHRIs have increased their work in the area of migration, and particularly since 2015, and of course the actions from the states which led to serious human rights concerns. That is done by NHRIs from countries at both sides of the external borders, but also at NHRIs operating at the internal borders of the EU. And what they have contributed to is a growing body of evidence indicating the existence of widespread violations of human rights of migrants, which are in line with the allegations and concerns raised by NGOs and by international and regional human rights bodies. What NHRIs do is that they take regular visits to border areas, they access documents, conduct and observe or interviews with migrants. Those NHRIs that are ombudsman institutions also receive complaints. And also from my experience, handling complaints either from migrants or from NGOs on their behalf is one of the most efficient tools at the disposal that can lead to evidence on the systemic misconduct. So they really give a unique insight into the situation. Some NHRIs also act as the independent fundamental rights monitors for forced returns, including those organized by the Frontex. Based on the findings, NHRIs provide recommendations to the government on human rights compliant practices, on international standards, and so on. And they report to the parliaments and to the regional and international actors. Very importantly, working with CSO, civil society organizations, and supporting them ensures specific synergies, as the capacities of both are very strained and particularly under pressure. And then NHRIs also take awareness raising activities such as campaigns, publications, cooperation with academia and schools, making use of the media, working with local communities, regional authorities, countering incorrect narratives on migration, and so on. There are many, many more examples, including country-specific, but you can find them on ENRI's webpage, and I've put it on the slide so that you can easily copied. There are many examples in this publication that you see on the screen, but also on the whole website, there is a specific landing page on asylum and migration. Of course, it would be too simple if NHRIs and their role is better recognized, appreciated, harnessed. And I would say there are two main types of limitations to their work. One is legal limitation of their mandate and their institutional setup. First of all, which I think is good, the fact that they don't issue binding decisions, but opinions and recommendations has its limits in itself. And then the other is that NHRIs do not conduct criminal, but administrative investigations, and they're not able to collect or secure or retrieve evidence that can be basis for criminal procedure. Rather, they either through complaints handling or preventive monitoring collect information. And then if those information point to a suspicion of a criminal offense, those would be referred to the district attorney's office. Another type of limitations derives from the political context. Because they are independent from the governments and their political agendas, NHRIs in many European countries have faced strong opposition from the state authorities. This opposition has materialized in several ways, as you can see on the screen, by not following on the recommendations, by refusing access to official documents and data, by discrediting the work, even by sometimes subtle and sometimes very open threats against the NHRI and their leadership. Finally, NHRIs by the definition have very limited resources, both in terms of budget and human resources. And the monitoring can be quite costly exercise, particularly field visits and border monitoring. So that is objective limitation that actually very often limits the work of the NHRI. Now, from a very practical point of view, this is what we did in Croatian Ombuds Office. And we started working on this in 2015. That was immediately after Hungary started building its fence on the border with Serbia, and when first migrants came to Croatia along what is later to be known as Balkan route. Our teams started monitoring the situation as it evolved at the border crossings, at the train stations, in transit centers. Some people call them camps. I'm sick to that term. And somehow I think we shouldn't hold people in the 21st century in any sort of camps. Primarily in 2015, it was a humanitarian issue. And we mostly observed if they have sufficient water, some food, change of clothes, medical assistance, shelter from the elements, and so on. We, of course, also observed police treatment, access to asylum, legal aid, the treatment of vulnerable groups. We talked to everyone involved, from the ministers to the migrants themselves. We issued recommendations on the spot and later on in communication, and many of which were actually immediately implemented. That was the beginning. That was 2015, early 2016. And that was also very emotional time, and it was inspiring also for us. It somehow led us to continue our work on migration issues. And what we did actually became known to NGOs, not only in Croatia, but also in neighboring countries. Then as the political situation in Europe changed with the signing of the EU-Turkey deal, so did the approach of the governments towards the migration flows. And soon after, we started receiving first complaints from the migrants themselves, but also from the NGOs working on their behalf. One large group of those related to the pushbacks at the green border, often accompanied with physical violence and stealing of property, mostly mobile phones. Other complaints referred to the denial of the requests for asylum in the territory of the state, not only when migrants were intercepted on the streets, but also when they came to the police stations with a clear intention to seek asylum. And then handling of those complaints was very interesting, as it was twofold. First of all, we would send communication to the Ministry of Interior asking for their written response and clarifications of the particular situation. And in addition, we paid unannounced visits to the police stations in question. And let me remind you that all of the public bodies have a legal obligation to respond to Ombudsman's requests, and that we had at the time legal right to access any information regardless of the confidentiality. Not only did those visits show discrepancies in the facts, discrepancies in the chronology of the events and the shortcomings of the ministry handling of the particular cases, it also showed systemic shortcomings, from blatant disrespect of national, European, and international legal norms to the concealing of the evidence. And of course, we referred those to the Attorney General's office. At some point, as we realized our work is not sufficiently effective, we did not succeed in influencing change in ministry's modus operandi, and then we turned to the parliament. Now, the political reality is that the parliament's majority creates the government, and perhaps it was too naive to think that that would change something, but at least we put up a fight. We showed resistance and gave voice to migrants in the parliament. We also worked closely with NGOs from Croatia, but also neighboring Serbia and Bosnia and Herzegovina and Hungary. They sent us many very credible complaints. And we also worked very closely together, including on joint visits with NHRIs from Serbia, Bosnia, and Slovenia. And then it backfired. Once we became able to clearly demonstrate the shortcomings of the MOI's operation, they started refusing access to the data in the police files, which unfortunately effectively prevented us from fulfilling that part of our legal mandate. And I will not go into more details, but if you're interested, you can find more information in the reports on the Croatian Ombudsman's website. Many reports are also in English. There's many information available. But the question remains, how do we measure the effectiveness of the NHRI's work when it comes to protecting migrants' rights at the borders, particularly in the political situation as we are facing? We perhaps helped some people, some of those that sent us complaints, but we did not change the situation for many. And we certainly didn't change MOI's treatment of migrants. What we were successful at is creating partnerships with like-minded parliamentarians, NGOs, media, with European and international actors. And we very clearly, strongly, and loudly reminded all actors about the legal norms and obligations. And we were continuously warning against impunity. Faced with increasing anti-migrant rhetoric in the public space, we tried to give migrants a human face and raise public awareness about their rights and needs, which is, and for some time already has been, increasingly difficult. I will always ask myself if that was enough and if we could have done more. But at least together with others, we showed that despite the political climate, it's important to fight for the values of human rights for all, and that gives me some comfort, at least. So how do we move forward? Here, I will again point out to the European Network of NHRIs, ENVI, which has contributed significantly to collecting information about the work of NHRIs in Europe in asylum and migration since 2015, both at national level, but also in engagement with EU policymakers. They published a scoping paper a couple of months ago, in which you can see it on the screen. They identified 4 key thematic areas which are subject to current or recent EU law or policy developments, and the potential of both NHRIs and ENVI's actions in these areas. And I will not go into the details of all, but I will focus on the first one, the procedures at the borders, because it's the most relevant for our discussion today. And that, of course, relates to the proposal for the screening regulation, because there is a reference there to the establishment of the independent monitoring mechanism to ensure compliance with the EU international law by each member state. Now, in light of the evidence of the systemic violation of human rights at the borders, that mechanism may sound like a good idea. Given that NHRI's broad human rights monitoring mandate is often coupled with the NPM and Ombudsman's mandates, they should at least be consulted, if not designated as independent monitoring mechanism. Or at least they can be used in a complementary manner to increase the effectiveness of whoever is designated as the mechanism. However, currently there are only 2 of such mechanisms that are being discussed. Actually, one already started operating, and that is Croatia and Greece. In Croatia, it was off the table from the beginning that NHRI could ever be designated as such, precisely because of its proven independent work, which government could never allow. And currently there is very limited information available about the mechanism, but it is apparently operating and consisting of 1 or 2 NGOs, representatives of academia, and they are supported, let me use that word, supported by the Ministry of Interior with very limited scope of monitoring activities in Greece, and that is the only information that's available on Croatia. In Greece, there is a similar discussion, as Ombudsman, who is not the NHRI, but is the NPM, could be best positioned to take the role, but it seems that the mechanism will actually be given to a Prime Minister office. So that much about independence, I think everything is clear. But we'll see how that goes. In Greece, it's not lost yet. Anyway, to conclude, existing human rights bodies, whether NHRIs, Ombudsman, NPMs, preferably but not necessarily combined, have legal mandate, they have independence, skills, expertise to monitor human rights situation and the rights of migrants at the border. And there are also serious limitations, like political will by the government, by like lack of sufficient financial and human resources. But at the same time, the situation at the external borders is going from bad to worse. And I don't think I need to remind anyone of the situation at the Belarusian border. So there is an innovative idea being looked into and discussed as we speak between some of those institutions and European actors to establish independent collective mechanism comprised of number of ombuds, NHRIs and NPMs from the EU member states, but perhaps also some from the external borders that would jointly monitor the human rights compliance by national law enforcement bodies and by Frontex at the external borders, and that would give recommendations and objective and substantiated reports trying to improve the situation. Now, this situation as it is not positive and optimistic, and I'd say quite the contrary, with building of fences between countries, with increasingly and extremely serious human rights violations, with blatant disrespect for international human rights standards, lack of accountability, widespread impunity. And this idea of joint monitoring by independent human rights actors, provided it has sufficient support, political support by European actors, might actually fill in the void in the current lack of any efficient monitoring at the border. I'd say any monitoring and then any efficient monitoring. And whether it materializes, it remains to be seen, but hopefully it's an idea that's worth exploring. So to finish, I would like to show you a video that my former office has put together at the end of 2015, trying to present our work, but also raise awareness of the human suffering of migrants. I think it shows well what an institution can do in the emergency situation such as that one. And I said it inspired us to do more and to work harder, and I hope you will find it inspirational as well. I will try to share it now. Of course, it's